Welcome to this explainer. If you are studying succession law, drafting wills, or navigating estate planning, you already know that missing a single rigid legal formality can completely invalidate a person's final wishes. It's high stakes. So today, we're going to break down the 9 distinct classifications of wills, straight from our source notes, highlight some absolutely critical drafting pitfalls, and touch on the evidentiary nightmares you're going to face in practice. Let's dive right in. Here is our roadmap for the discussion. We'll cover privileged versus unprivileged wills, holographic and nuncupative forms, multi-party joint and mutual wills, special edge cases, the inefficacious will concept, and finally the fascinating Ree Harris estate case study.
Section 1. Privileged versus unprivileged wills.
Under the Indian Succession Act, or ISA, the law establishes 2 primary status-based categories. Active military personnel, so that's your Army, Navy, and Air Force, are granted special privileges under Sections 65 and 66. Because of the inherent dangers of their service, the law actually relaxes the rigid execution requirements for them. But for the rest of the populace, unprivileged wills must strictly follow the procedural rules laid down in Section 63. Now listen closely, because here is a massive drafting pitfall. Do not assume someone qualifies for a privileged will just because they have a military background. Our notes specifically highlight that they must be on active duty. If you draft an unprivileged will for a civilian and fail to follow the strict attestation requirements of Section 63, that document is essentially worthless.
Section 2. Holographic and nuncupative wills.
So, a holographic will is one that is written entirely in the testator's own handwriting. What's really interesting here is why the law looks so favorably upon it. The handwritten nature strongly proves the testator's mental capacity, right? It clearly demonstrates they were of sound mind and capable of organizing their thoughts onto paper. Consequently, it requires very little proof to establish its validity. It's a highly personal document, meaning there's a strong likelihood it was executed properly by the testator themselves. Now, flip that concept entirely on its head, and you get the nuncupative will. This is a purely oral will. And from a drafting and evidentiary standpoint, it is an absolute nightmare. Because there's zero paper trail, the risk of fraud or misinterpretation is astronomically high. Because of this, the law strictly limits nuncupative wills to very specific, exceptional circumstances. Honestly, as a legal professional, you'd practically never advise relying on an oral will unless extreme, imminent circumstances made writing literally impossible.
Section 3. Multi-party joint and mutual wills.
You absolutely have to nail the difference between these two for your exams. A joint will is just a single document signed by 2 or more testators. It's really just an administrative tool. Upon the death of each testator, it operates as their own separate will and gets admitted for probate. But mutual wills, completely different beast. They involve reciprocal benefits. Imagine A gives their properties to B and B gives theirs to A. These are incredibly common for married couples with children from previous marriages. The strategic goal here is to protect those blended families, ensuring that upon remarriage, the property still goes to the deceased person's children, rather than a new spouse. The crucial drafting point to remember is that mutual wills become irrevocable after the death of one partner, provided the survivor received benefits and there was an agreement not to revoke. The legal boundary line for this is perfectly illustrated in the case of Meenakshi v. Vishwanatha. Generally speaking, a sole surviving testator is totally free to revoke their own part of a joint will. However, this case proves that you cannot happily enjoy the benefits of a deceased partner's will and then selfishly turn around and revoke your own. Equity steps in. If you've taken the benefit, you are bound by the mutual agreement. Failing to clearly spell out whether a joint document is intended to be mutually binding is a classic textbook drafting error that leads straight to equitable intervention in court.
Section 4. Special circumstances and edge cases. First up in our edge cases is the conditional or contingent will. This one is entirely dependent on a specific trigger event. The source notes give us a classic example. If anything happens to me during this sea voyage. People generally use these to ensure the safe appropriation of their property before traveling, or sometimes to encourage legatees to perform certain deeds. The huge danger here, vague drafting. If your condition isn't crystal clear, a probate court will get bogged down trying to figure out if the contingency actually happened, or if the document was just meant to be a permanent will anyway. If the contingency event doesn't happen, the will simply becomes inoperable.
Next is the duplicate will. It's exactly what it sounds like, a copy of the original will handed over into someone else's custody. But here is the catch. It cannot just be a simple photocopy. It absolutely must be executed and attested exactly like the original under Section 63. And watch out for this legal trap. If the testator revokes the original will, it automatically revokes the duplicate too. The duplicate has no independent life of its own whatsoever. Then we have concurrent wills. These are all about administrative convenience. A testator creates completely separate wills to dispose of different properties, which happens a lot when someone owns assets in different countries across different jurisdictions. The golden rule for drafting these is explicit limitation. The testator has to clearly declare that each will deals exclusively with a specific aspect of their affairs. Want to know a classic drafting disaster? It's the lazy use of a standard, I hereby revoke all former wills boilerplate clause in the second concurrent will, which accidentally destroys the very first one.
Section 5. The inefficacious will concept.
Now we confront the will that causes the most familial drama. An inefficacious will completely ignores the testator's natural affection and moral duty. It means the property is gifted entirely to strangers, to the complete exclusion of a wife, kids, or other natural heirs. But here's the kicker. Our sources confirm it remains legally valid as long as all other execution requirements are met. For a drafting attorney, this brings up massive strategic and evidentiary hurdles. If your client wants to disinherit their entire family for a stranger, you better anticipate a fierce legal challenge. You need to meticulously document their mental capacity and prove beyond a shadow of a doubt that there was no undue influence. Because an inefficient will, it is a giant red target for probate litigation.
Section 6. Case study Reher-Harris Estate.
Okay, picture this. It's 1948 in Canada. A farmer named Cecil George Harris is pinned under his completely mangled tractor. Knowing he probably won't survive, he reaches for his pocket knife and physically scratches these exact words into the tractor's fender. In case I die in this mess, all my property to my wife. It's a conditional statement and an incredibly desperate final act.
Harris tragically died 2 days later in the hospital. The fender was actually cut off the tractor and brought right into the courtroom. And because that scratching was made by his own hand, it was held as a legally valid holographic will in Canada. However, we need a quick jurisdictional reality check here. If this incredible last effort happened in India, our notes point out it would hit the brick wall of strict attestation rules under Section 63 and likely fail simply because he was an unprivileged civilian without witnesses. Take a mental snapshot of this summary table. This is your ultimate exam checklist. We've navigated everything from the active military privileges of Section 65 and 66 to the total vulnerability of oral nuncupative wills. We've looked at the drafting landmines of joint and mutual agreements and the heavy litigation risks of inefficacious wills. Every single one of these 9 types serves a specific legal function, and confusing them in your drafting can lead to catastrophic consequences for an estate. So I'll leave you with this final thought as you prepare for your exams and study gripping edge cases like Reher-Harris Estate. The law clearly demands strict adherence to rules like Sections 63, 65, and 66 to prevent fraud, but does that rigid bureaucracy sometimes rob people of their true final intentions when chaos strikes? Keep that tension in mind as you go out there and learn to draft truly airtight wills. Thanks for joining me on this explainer, and keep questioning that delicate balance between the letter of the law and the human lives it governs.